Consider this contract.
All right, our final case this morning, 23-239 Baker versus BLC Atrium Jacksonville. 20 minutes per side. Appellant can reserve as much of that as you would like for rebuttal. The default's 5 minutes. If you want anything other than that, please let me know. And with that, Mr. Brownlee, if you're ready, you may proceed.
May it please the court. Good morning, Your Honors. Almost good afternoon. My name is Mike Brownlee. I'm here on behalf of the appellant, Daryl Baker, and I would like to take 5 minutes for rebuttal.
Yes, sir.
Your Honors, this appeal arises from the dismissal of Mr. Baker's lawsuit with prejudice for fraud in the court. And before we get into it in earnest, I want to make something really clear. Mr. Baker understands, I understand the trial court's frustration and concern, the appellee's frustration and concern. Anytime a party answers a question under oath incorrectly, it's a problem. It deserves to be vetted. Our position is simply that the punishment doesn't fit the crime.
But this didn't happen one time, right? This happened several times.
It happened in his deposition. There were 2 questions he answered incorrectly, and then
About the interrogatories.
the update interrogatories, he failed to update them. When he answered the original interrogatories, the answers were correct. He had not started working at Amazon or suffered any sort of injury. So, but yes, that's correct. He didn't update his interrogatories like he was supposed to.
What about to the life care planner?
Well, I think the life care, if you read the report of the life, we didn't have any testimony from Dr. Lieber, who was the life care planner, and I think if you read his report, it's less clear than it's made out to be in the briefing, in my opinion, about his responses to questions about his current employment. I think when you read the report and he's asked about his employment, to me, I mean, again, you're reading from a cold record, but it looks to me like he's responding to a question about his employment with the newspaper, rather than just his employment in general. I'd like to focus, we raised a series of arguments in the briefing, but I'd like to focus the court's attention today on 2 sort of main issues. And one is the burden of proof that the appellee had to justify the extreme sanction of dismissal, which is clear and convincing evidence. Mr. Baker testified at the hearing that memory problems and cognition problems were the basis for his inaccurate reporting in the discovery and in the deposition. Whether you believe that or not, it was unrebutted. There wasn't even one question asked in cross-examination. There was not a witness called to challenge his testimony that that was the basis for his problems. And there's support in the medical records for his explanation. He got his bell rung badly when he fell at the senior center. That's not disputed. And I'd like to point the court's attention at page 1352 of the record. There's a recap of Mr. Baker's visit with the neurologist, and this is 2 years after his deposition, where he's being treated for decreased memory and retention, and he's struggling with cognition. Those are direct quotes from the medical record. At page 1354 of the record, he's visiting an optometrist, and the optometrist notes that he has brain damage.
But isn't the problem that the trial judge had, I'm gleaning from this record, that it's not like your guy was asked a question, did you see a chiropractor 8 years ago and you forgot about your... He was asked a question about what was he doing now. I mean, he's working at the time he's being deposed, and he can't remember that he's working or he'd been injured there, and the judge finds that incredulous, or I can't remember the term exactly, and yet your client remembers other things. So the judge gleans from that information as the trier of fact, the weigher of credibility, that I don't buy it. I mean, it's one thing you don't remember stuff before you, and granted, as you get older, you remember less and less. I get that, but it's happening at the time, and you tell somebody the exact opposite of what's happening to you. In other words, did you go to work today? No. Well, you were at work. What are you talking about? How do you not remember you were at work before you came to? I mean, I know it wasn't that graphic,
No,
but
I understand.
But I think that's what's the sense of what the trial judge is doing.
I think that's an accurate, recap of what the trial court's concern was, definitely.
And even though there's no testimony from your opponent's side saying, there's no evidence of brain injury, the trial judge doesn't have to accept that the brain injury causes this kind of memory lapse, does he?
No, I think in the ordinary circumstance, no. But where it's supported in the medical records and it's not challenged at all via testimony or even a single question on cross-examination, I mean, it's really just floating out there unrebutted. I do think in that circumstance, given the gravity of the right that's being taken away, which is your constitutional right to a jury trial, I think you put that to a jury. You know, the jury.
So absent any evidence of brain injury, if your client provided these same kind of answers, you've got a real difficult time reversing this.
100%. And I think, Judge Lambert, that's what distinguishes this case from the other cases that talk about, look, you can't just say, you know, I forgot,
Yeah.
right? I mean, because in those cases, the courts take pains to note that there is not any sort of evidence to buttress that explanation. But here there is. And I think it's enough to show that the Senior Center did not prove their case by clear and convincing evidence. So first issue is the clear and convincing evidence standard. The second one is the materiality of the shoulder injury and his Amazon employment to the facts of this case and the type of damages he's requesting. He's never requested damages associated with the shoulder injury. It's for his neck surgery and for his back. It's simply not a part of the case. The shoulder resolved. It's not an important part of the case. And I think one fact that underscores that it wasn't an important part of the case is that the Senior Center knew about this for 2 years before it filed its motion to dismiss. For 2 years. Logic would suggest if this is truly the central, you know, a pivotal piece of the case, like it has to be under the law, that the Senior Center would have broached this issue in some, you know, way, shape, or form, you know, after the summary judgment motion had been denied and they're at the eve of trial and they're about to go to trial. You know, you would think at least in their summary judgment motion or elsewhere that there'd be some discussion of this or some effort to adduce testimony about it or whatever. But sitting on it for 2 years without doing anything about it seems antithetical.
So you're arguing they're not prejudiced? Is that what you're arguing?
Correct. Yeah.
Is that an element, though, of dismissing this
It's
with
not.
fraud?
It's not, as far as I know. Well, let me temper that a little bit. I mean, I think a lot of the cases talk about, you know, is this scheme to defraud? Does it hamper the defense and then their presentation of the case? And I think here, absolutely not. It didn't, because A, it's not a central issue, and B, they had this information for 2 years, didn't do anything to vet it.
That was not a central issue, though. I mean, you allege in your complaint he has an inability to lead a normal life, and then he's out working 40 hours a week at Amazon moving boxes.
It wasn't 40 hours a week, but understood. You know,
What was it, 36?
I think
Was
it,
that
I
three
think- I think
12-hour
it- I think it
days?
varied. I think it varied.
3 12-hour days a week, I thought.
Yeah, I think in some instances that's correct. I think he also testified that there were 4-hour shifts, but I understand your point. But, you know, the loss of enjoyment of life, the damages he was claiming, they were associated with his neck and his back, and this is stuff that could be easily
But
dealt with the jury.
Even though he decided not to pursue a lost wage claim, this seems to be an apples to oranges thing. I mean, let's say he wasn't working at Amazon. Let's say he was working as a minor league professional hockey player. And during the same period of time, he's being deposed. And so he's being knocked into the boards, gets in fights, and going back and forth. A very, very vigorous, difficult sport. And that was his job. And he's asked by the opponent in deposition, well, are you working? No, I'm not. Well, okay, but he is. He's working as a hockey player here, and maybe we don't hear him because he's not a professional hockey player. I don't see him on TV. But, I mean, that goes to his ability to do things, to enjoy life. I mean, that would certainly be a critical thing, I would think, if you're on a jury, is saying, well, wait a minute. You slipped and fell, and you're asking for all these damages, but here we see that you're a hockey player.
Right.
So you're probably not really in that great you might be in a lot of pain and suffering from playing hockey, but it may not be related to this, so it greatly affects how a jury would look at the value of the case, and to not disclose it. Again, let's use my hypothetical. Let's say he had no brain injury. Not disclosing that would seem to be almost the epitome of trying to be fraudulent and to hide something so that hopefully the opponent would not discover that I actually, in full contact karate, hockey, or whatever I'm doing, and maybe I don't really need $500,000 for rehab or what have, or future medical care. I mean, that's kind of
I understand.
So, I mean, the argument that, well, it's not a lost wage claim, I sort of like what Judge Boatwright is saying, that to me is not the critical thing. The critical thing is you're doing a job that apparently requires some type of physical labor that's inconsistent with what his claims of how his life has been affected by the slip and fall at that guy's place. And you didn't want to talk about that, or you intentionally told somebody a different story. Because if you said, yeah, I'm working, and they say, oh, what do you do? Well, okay. That causes a reevaluation of the case from both sides, I would think.
Yeah, I understand.
Yeah,
I mean,
fine.
I think if you stack this case up against the other cases that say, nope, it's okay to dismiss someone's entire case with prejudice, the facts of this case, they don't stack up.
But we look at, I mean, and the other thing that weighs against you, I mean, your judge got to listen to your fella and make credibility calls, and then we have to look at those. We defer to the factual determinations of credibility calls as an abuse of discretion, although it's a heightened abuse of discretion standard that we apply, which I guess means that it's not a complete abuse of discretion. It's, yeah, you know, we're looking at you a little more closely than just saying, well, it's a discretionary call, and we might have done something different, but it's a discretionary call.
Right. Not no reasonable judge, just a semi-reasonable judge. I don't know.
Find a lot of those around here, but
I understand. I understand. I suppose the upshot of our argument is this is stuff that could be dealt with a jury. If this court reverses and gives Mr. Baker his day in court before a jury, he's going to have to answer for all of this. It's not like this is just going to be swept under the rug. He provided this inconsistent testimony. This can all be presented to the jury, so his constitutional right can still be preserved, and at the same time, he can answer for the misdeeds that.
So at some point, you were served with these employment records, that the other side served you with employment records from Amazon that showed you that, now, wait a minute, they know that he's working at Amazon. Prior to that, them serving those records, did your client ever indicate or inform the other side that he was working at Amazon?
I wasn't trial counsel, Judge Boatwright, so I'm not positive, but I think you're correct. I don't know. I do not think there was a disclosure by him prior to.
Until the employment
I
records
think that's
came
right.
in? Okay.
That's my understanding.
well, they subpoenaed the work comp records out of Tallahassee, too.
So,
when that-
so he testified to two other work comp injuries in the past, and I think in the course of requesting records from those two, they found the records from the
From the
Amazon
work comp
one.
claim from at Amazon.
Correct. So, yeah, I mean, again, we would just underscore,
Prior to that, he had not disclosed
no,
anything.
that's correct, Judge Boatwright, at least from my understanding of the record. Again, I wasn't trial counsel, so I'm not
But
positive.
this is always kind of the argument that you, in any kind of, quote, fraud case, I use that just generically here for the purpose of the discussion, I'm not accusing one way or another. It's always the argument says, well, okay, you got caught in lies here, you can always bring that on cross-examination. At some point, there's a call that's made at the lower court saying, okay, this is too much, it's a punitive event here. You've waived your right to pursue this because of your fraudulent behavior in trying to not present the true facts of the case so that the trier of fact can make a call based on all the admissible evidence. I mean, and so at some point, you know, that side's always going to say, oh my God, look what he did, dismiss it forever. Your side's always going to say, I mean, your side for today. I mean, I'm not saying
I understand.
you're pigeonholed on one side or another. Your side today would say, look, yeah, we all agree what happened. Grill them on cross-examination. If the jury wants to say, hey, pal, just don't buy it, that's the jury call. That's our right under the Constitution or things like that.
I understand, and the judge has discretion, and it's, you know, the law affords the judge the discretion to draw a line in the sand and say, you know, you're out of luck now. We wouldn't be here, I wouldn't be here before you if it wasn't for the unrebutted explanation that's supported by medical records in the record. If the senior center had, you know, cross-examined him, asked him, you know, I don't know, brought in an expert, even called his wife to the stand and said, okay, he's saying that, you know, you have to help him a lot with his day-to-day life, you know, something. But to have an unchallenged, unrebutted explanation that's supported by medical records, I think takes this case out of the line of cases the senior center is depending on, and I think compels a reversal in this case. Unless the court has any other questions, I'll go ahead and reserve.
How's your wife liking her new job?
Liking it just fine. A little less hectic than the, you know, day-to-day rigors of being a trial judge, which I know you know about.
Amen.
Thanks, Your Honor.
All of us do know about that. We're all former trial judges here.
Yep. Okay, Mr. Incline.
Good afternoon. Clemente Inclan on behalf of the appellee. As your honors have already alluded, some of the issues that are key are this issue about brain issue, of whether or not he had a brain, Mr. Baker had some sort of evidence of brain damage. The records do not show any diagnosis of brain damage. And we can comb through it, we can look at it, and all we see is an EMS record. We may see a record of an ARMP where Mr. Baker may allege or may state something that he has a memory issue. But there's no diagnosis at all whatsoever in any of those records that I'm aware of. I have not seen it. In addition to that, the only medical opinion in the trial record comes from Dr. Romano himself, who says, look, I believe Mr. Baker had a concussion maybe, and that's the kind of thing that would have, within a couple weeks, he would have been back to normal. And therefore, he doesn't suffer from any memory issues, any brain damage, or anything like that. At the hearing, I did ask Mr. Baker a number of questions. I asked him questions to elicit, hey, do you remember that you worked at Amazon? And he said, absolutely. I didn't ask him, sir, do you have a memory issue? What I did ask him was, do you recall working at Amazon? Yes, I do. Do you recall working, signing an application? I remember, yes, I do. In fact, I remember that my wife did it and that I approved it. I asked him about the fact that, well, what were you working? What were you doing there? And those questions were all for the purpose of eliciting what is his memory, which he could remember all these things about Amazon at the hearing, but he couldn't remember it allegedly during the deposition while he was in the process of suing Amazon and still an employee of Amazon. We would submit, Your Honors, that this is a case of clear and convincing evidence. First, that Mr. Baker claimed that he suffered certain injuries, that the discovery, however, that the defense had to go through via countless subpoenas and all the processes that have to go through, were able to find documents that significantly put into question the plaintiff's claim of injuries, if not entirely refute them. But they are these Amazon records certainly really put into question these claims that Mr. Baker has. We believe that the evidence shows that that this was an intentional act on the part of Mr. Baker to not reveal this information.
Well, it has to be for you to have won below.
Well, yes, sir.
I mean, fraud is not, you don't negligently commit fraud. I mean, the judge in essence determined there was fraud on the court, so it was an intentional non-disclosure of critical facts occurring at the time of the deposition. I mean, it's a different scenario that we typically see where you forget that you treated years ago, and then that comes up in a records pickup by insurance defense lawyers.
Yes, sir.
And so, yeah, this is more of a unique case that I'm forgetting something that's going on at the very moment I'm being deposed.
Yes, sir, and that was exactly the next thing I was going to say. It's very unique when you as the counsel are reviewing and you're like, wait a minute, this is what Mr. Baker said in deposition, and then we're putting the pieces together as we move along through the discovery of the case.
Mr. Brownlee wants to know why you took so long to file a motion to dismiss with fraud.
Well, you know, there's in a trial practice, there are many other things that occur in addition to filing a motion to dismiss for fraud, depositions, discovery, mediation, all those type of things that are ordered by the court that were complied with in this case, including discussions between counsel, which occurred for months and months. I would submit to this court that what is clear is that the plaintiff, Mr. Baker, he claims that he had severe, grievous, and permanent injuries, an inability to lead a normal life. Those were his claims in the amended complaint. In his interrogatories, he said that he could not work. He also said that he could not sit, he could not stand for long periods of time. And in interrogatory number 11, he said that he's seeking damages for past and future pain and suffering. But we see, as Your Honors have already alluded to, in the Amazon records, he claims he has no disability. He claims he can do all of these things that he is claiming that he cannot in his responses to interrogatories. Those responses to interrogatories occurred on January 14th of 2019. His application to Amazon was in May of 2019, just 4 months after the fact. So we see responses saying he can't do something, and we see an application just a few months later saying...
Mr. Brownlee would say that's good stuff for cross-examination. See, you ended up getting better there in that period of time. You're no longer complaining by the time you applied for work at Amazon.
Yes, sir, and I think to Your Honor's prior point, I think anything could be offered for cross-examination. He lied at the alleged, if he were to lie in front of the court, if he were, sure, anything could be presented to a court on cross-examination from the jury. But I think that the system, the judicial system, as the courts state, if you have a system that you rely on having to find the truth through the discovery process, that's a system that's doomed to fail. And there has to be, from the courts, a point where you say, well, how much is how much, where it's clear that the person was not being truthful, where there's...
Well, dismissal with prejudice as a sanction is pretty drastic. Wouldn't you agree?
It's pretty drastic, yes, sir, but it's warranted when in this case you see an individual...
It's warranted in every case where a party is not truthful in discovery?
No, sir. No, not at all. And as a 30-year trial lawyer, impeaching a witness on the stand is part of what we do. But when a witness is not truthful in deposition, when a witness then doesn't tell his life care planner that he has not worked, he doesn't tell his own life care planner these facts, then, interestingly enough, when you look at all the treaters that he was treated for the Amazon injury, he doesn't tell them anything about the Brookdale injury. And interesting, when you look at the Brookdale treaters, Mr. Baker doesn't tell them anything about the Amazon injury. Now, that is if that's not I don't know how one can be that consistent if one has a brain injury where you know who to tell one sort of injury and history, and you tell a whole different set of treaters something completely different. So we see...
Brownlee would say that's why I would put some doctor on the stand to be able to explain that to a jury, and then they could weigh that and determine the extent of his, the explanation as to why he gave you incorrect answers in the deposition. And it's not a forfeit of a jury trial right. It's a thing for the jury to answer.
Yes, sir, and I understand that argument. My only response to
I
that...
should go down there and sit for him. That's all right. Sounds like I'm being an old appellate lawyer.
Yes, sir, and I understand that. And again, I go back to my point. That argument can be made on the plaintiff's side for anything. No matter how egregious the improprieties of a plaintiff, He
acknowledges that, though. I mean, he basically said if there's no evidence of brain injury, and he's still saying that, then he wouldn't even walking in the door today or something like that. So, yeah, he's saying that. Yeah, but this is the wrinkle here in the case. Why it's for the jury to ferret out, not for some trial judge to make that call.
Yes, sir. Yes, sir.
What's wrong with that argument, or why is that not persuasive today?
Well, because it's the nature of the egregiousness and how clear it is that this person was creating a scheme. I think that's what the cases require the defense to show. I can't really make an argument if somebody just makes a mistake, which happens, sure. A person is inconsistent, it happens. The difference is where the case law sets out that if there's a scheme to try to hide information that will be important for the purposes of adjudicating a case.
That's what he's saying. My guy has this brain injury, so how could he develop this scientific scheme, whatever term that we used back in Cox 100 years ago? how can he develop that ability to have that scheme if he doesn't have the mental wherewithal to do that because he's been injured?
Yes, sir. And I understand counsel's argument. I would just point back to the fact that there is no diagnosis of that. There's no diagnosis of medical condition, of a brain injury, of memory loss. The only record evidence that the court has is Dr. Romana, the defense CME expert, who says that I interviewed him, I asked him questions, and he at most had a slight concussion after this alleged fall. I would also point out...
When was the fall in relation to the deposition? Couple
So-
years?
Yes, sir. Yes, sir. So, yes, sir. The fall was in May of 2018, and the CME was in 2020. So quite some time had passed during that time, including the fact that he had worked. Back to Your Honor's questions before, counsel argues that, well, Mr. Baker and the underlying case, he is not claiming lost wages or earning capacity or that he has a shoulder injury. He's not claiming those things. But the fact that he was able to do these things at Amazon go to the heart of the case, and that's our point. Opposing counsel argues in his brief that the trial court did not account for Dr. Romana's interview, and the fact that Dr. Romana apparently had this long conversation with Mr. Baker, that Mr. Baker was allegedly coming forward with information about Amazon. And I would submit to this court that that's not in Dr. Romana's record. All Dr. Romana in his record states is that he evaluated him for a shoulder, he asked him about his shoulder, and that his shoulder was fine. Dr. Romana did not even have the Amazon records at that time to be able to question him about that. Regarding Dr. Lieber, opposing counsel argues concerning what information Dr. Lieber had and the fact that in his second life care plan, Dr. Lieber at that point did have records concerning the injury. But what Dr. Lieber did not have is the Amazon records. He did not have the Amazon records to be able to compare what Mr. Baker was actually able to do versus what he was in his initial life care plan indicating that he couldn't do. He couldn't do 80% of housework. He couldn't do 50% of this. He couldn't do 40% of that. If Dr. Lieber had had those Amazon records, he could have seen that that's very inconsistent. And Dr. Lieber never had the Amazon records. And he also did not interview Mr. Baker in the for the second life care plan. And I'll start wrapping it up here. In terms of the memory loss issue, I would just point out that the point that he consistently omitted information and he selected who he gave information to versus the treating doctors, not only Dr. Lieber, but the treating doctors from the Amazon care and the Brookdale care. I would point out further that in the underlying evidentiary hearing, I never did concede that there was a brain injury. The only thing I said in the record was that the plaintiff alleges that there was.
What facts do you think could be added to the record that would suggest that there was an abuse of discretion here? I mean, you're arguing that we all agree, counsel agrees, it's an abuse of discretion, this heightened abuse of discretion standard that people talk about. I think I actually talked about it in an opinion. I'm sure why, but so your position today is please affirm it because there's no abuse of discretion based on the record here. What do you think? What else? Where would you think the trial court would have abused of discretion? What other factor in this case could have been added that would suggest it's abuse of discretion on your part? Just trying to get the kind of a feel about this heightened abuse of discretion standard, even though I wrote about it.
Yes, sir. And I'm not.
What did I mean when I wrote that?
Respectfully, I'm not sure that I'm understanding Your Honor's question.
Well, in other words, you're saying this is not an abuse of, at some point there is an abuse of discretion in a setting like this. What do you think what else would have had to happen here below if the judge still said, you're still out, the case over, you're dismissed with prejudice? What other facts would be could have been in the record that the judge ignored that we would look at as abuse of discretion?
Well, if I understand you, Your Honor, correctly, I mean, I think it would have been abuse of discretion if we didn't have an evidentiary hearing, if Mr. Baker had not given an opportunity to present at the hearing, which he did.
What if a medical doctor came in and said, of course, this guy has clear memory loss and difficulties, and it's certainly explainable why he may have been working at the time he was deposed and he couldn't remember that, and here's the medical or psychiatric explanation for that doctor, and then they have 3 doctors who say that, and the trial judge says, "Psh, I know better. I am the credibility weigher. I reject all of that." Would that be abuse of discretion for us to not, an abuse of discretion for the trial judge to still dismiss with prejudice?
Given that's an interesting, it's an interesting hypothetical, and I think I would respond to that, Your Honor, by saying that the life care plan, if we look at the life care plan, it probably has 30 pages of a medical chronology of different providers that Mr. Baker went to. He went to neuro, he went to back, he went to pain, he went to everything.
Well, I mean, I know I sound like I'm saying a little bit tongue-in-cheek here, but pragmatically, we write these wise things theoretically up here, but it still goes back to you guys and to trial courts to say, okay, well, how does that actually apply when you write these nice legal principles here? What does that actually mean in real world when you guys are presenting evidence and a trial judge is listing evidence and having to make these rulings? So, it's kind of, this is too much, or in this scenario, this might be enough to be abuse of discretion if you listen to that and still dismiss it. That's kind of the whole purpose of my hypothetical. I sound like an old law professor at the University of Florida here that shall remain nameless. Maybe actually deceased too, but go ahead.
Yeah, I think my response on that, Your Honor, is you have to look as, is there a scheme and the extent of the scheme. When he was given an opportunity in the update interrogatories, which were months later, he could have cleared this up, and he didn't.
So if Mr. Brownlee's trial counsel had put on evidence that said, Judge, I know what the law is here, this is no schemer. He doesn't have the wherewithal to scheme. He just has this brain injury, he has CT, whatever he has. I'm not trying to, impact your Mr. Baker with illnesses that he hopefully will never have, but, that's the guidance. We should be giving guidance when we write stuff here. At least that's my view of some things here. It might not be the view shared by others, and that's their prerogative. But
Well, perhaps this might be helpful. If we look at his pleadings, plaintiff doesn't claim memory loss or brain damage, and he doesn't do so in his interrogatories, in his responses. In his own deposition, he doesn't claim it.
So if he had done that all the way along before he was made these answers in his deposition, then that would be factors that would benefit Mr. Brownlee's side.
I think it would be considered. I mean, I think there are some cases that the courts is very aware that it's very easy for a plaintiff just to say, well, look, I think I must have some sort of memory loss. And just coming in at the last minute and saying I have some memory loss, or at any point arguing memory loss, doesn't in and of itself is not sufficient. And here, what the clear record is that we don't have a diagnosis of memory loss. We don't have a diagnosis of a cognitive deficit. And in all the years that the case was going forward, and the time that I guess I didn't bring up the motion to dismiss for fraud, there was certainly the opportunity to have an expert, like you suggest, Your Honor, and that was not presented, and that's not part of the record. So we're left with what the record is in this case. And again, if the plaintiff was claiming this, one would think that it would be in the complaint or in the interrogatories, in the updated interrogatories, or something pled that says there's brain loss, memory issues, and there's not. At any rate, I thank you for your questions. We believe that the trial court had an opportunity to see Mr. Baker, question Mr. Baker. In the deposition, he is in a unique position as a trial court to do that. And for those reasons and all the other reasons that we stated in our brief, we believe that under an abuse of discretion standard, the trial court's order should be upheld. Do you have any questions for me?
I think we're good. I think we're good.
Thank you very much.
Thank you, sir.
May it please the court? I'll be brief. I know this is your last of many oral arguments today. Your Honors, the reason everyone is cherry picking from these records, right? They're saying there are some records that show that he doesn't have brain damage. Again, I pointed you to two specific places in the record for 2 years after his deposition, pages 1352 and 1354, where he's being treated for decreased memory and retention and for struggling with cognition. So there are some records that support our allegation that he has brain problems that affect his memory. There are some records that support theirs. But it is their burden to put on clear and convincing evidence to take away Mr. Baker's constitutional right to a jury trial. They failed to do so. That's why we're sitting here talking about, both sides are cherry picking, for lack of a better term, stuff that's helpful for them and supports their respective positions.
But I mean, isn't there some threshold though, at some point to say, oh, okay, you may have some, you have some brain scenario, brain injury, or whatever the term was being used, but that doesn't mean you remember. It seemed like for a trial judge would be within his or her right to say, hey, look, okay, I get that, I hear that, but I don't understand how can you forget something that you're doing right that same day. And I don't have enough other than that to suggest that what you are telling me that you have, or what I'm reading in these medical records, gives me enough of an explanation to justify why you have flat out told an untruth to the question, and therefore I don't buy that what your brain condition is causes this. That only leads me to the other conclusion. You're intentionally trying not to let me know about, or let the other side know about, a real salient factor here. Your ability to do a lot of things, your ability to enjoy life has not been impacted, therefore you've crossed the line. I mean, that's kind of where...
I understand. And I think, again, if in the absence of medical records that support his claim, and the absence of even a single question on cross-examination, right? I mean, this is how this should have worked, at least as I see it. Okay, Mr. Baker says, I have memory problems, I have cognition problems. There's a question that says, okay, do you really? How come? Where is that shown in your medical records? At that point, Mr. Baker's lawyer can say, well, here it is, the places I'm pointing you to in the record right now. Here's the medical records that support his explanation. None of this stuff is fleshed out. And that's the issue from my perspective, is it's a failure of proof. There's not clear and convincing evidence of a perpetrated scheme to defraud when there's not even a single question asked to challenge Mr. Baker's explanation. And if this court believes that, on those facts, a trial court with this heightened abuse of discretion has, it's within its purview to say, I just simply don't believe you, okay, then we lose. I get it, but I don't think that that's how it's supposed to work. I think if he gives an explanation, it's not challenged, there's not a question asked about it, and there is support in the record that supports his explanation, that's not clear and convincing evidence. It's simply not carrying a burden of proof. So, in the absence of any other questions, I'm going to sit down.
All right.
Thank you, Your
Thank
Honor.
you both very
Appreciate it.
much. Well briefed and well argued.
So we're going to stand adjourned?
We are adjourned.
All right.
Say the magic words.